Member for Sandwich Gulf Islands.
Thank you, Madam Speaker. And it is an honour to be able to rise at report stage, and I appreciate the decision of the Speaker to recognise that if there was ever a time for exceptional circumstances and exceptions under our Standing Order 76 sub 1 sub 5, this is such an occasion. And his use, Mr. Speaker, the use of the Madam Speaker of the exceptional circumstances here to allow a real opportunity at report stage to improve the bill. This is not a fake debate about amendments that have no hope. It is my profound hope that the amendments before the House now, as we debate this at report stage, with a free vote, with every member allowed to weigh in, we can yet improve this legislation to the point where I think the vast majority of us will be comfortable voting for it with amendments. As it is right now, I don't know if this bill can pass this House in its current state. So let me just go back for a moment for context, because I do think context and empathy are important on all sides of the House. This bill, C-14, is the direct result of the Supreme Court of Canada's unanimous decision in February 2015 to accept that certain provisions of the Criminal Code violate the Charter of Rights and Freedoms insofar as they affect people who are suffering from grievous and irremediable medical conditions and wish to have the right to choose their own time and way of dying. As the court wrote at the time, an individual's choice about the end of her life is entitled to respect. So there's not been, I can't imagine, certainly in my time in Parliament, there's not been a bill that's more difficult to talk about, that touches on aspects of our own personal principles, faith, beliefs, rights, and politics, all wrapped up in a charter decision. It's been difficult to talk about, but I think it's been approached on all sides with appropriate respect. And as my colleague just mentioned, the chair of the Justice Committee, the Honourable Member for Mount Royal, did an exceptional job in steering through the many amendments that were reviewed in committee. But not enough of those amendments were accepted to make the bill acceptable. Let me go through why I don't think I can vote for the bill without amendments. It's not about what I think. It's not about, Madam Speaker, whether I think the bill is satisfactory. I think everyone on all sides of the House, including government members, admit that it's flawed. It's not quite what one would want compared to, for instance, the exceptional report of the committee that guided the government, the joint committee report of the House and Senate on how to respond to the Carter decision. This bill falls short. But that's not the basis on which I can't vote for it now. And it's not my opinions. Our challenge as parliamentarians is to ensure that whatever we pass meets the standards set out for us by the Supreme Court of Canada in assessing what was it about the status quo that made the situation for Kay Carter one that was not merely unfair, but a violation of her charter rights. That's the key question here. There's a level of provision for medically assisted dying below which government legislation can't sink. And that bar, that line, is charter rights as set out by the Supreme Court of Canada. So I wanted to comment and focus a bit on this question as set by the court. An individual's choice about the end of her life is entitled to respect. I suppose we could wish that the court now used the female pronoun and intended it generically, as we've heard the male pronoun used throughout our lives to be used generically. But I think it can be inferred that the Supreme Court of Canada, using the female pronoun, is talking about the plaintiff before them. They're talking about Kay Carter. And would Kay Carter have access under Bill C-14 to medically assisted dying? And most observers at this point that I've heard, knowledgeable observers, do not believe she would. That, to me, is the crux of the debate, which means that her charter rights would still be infringed even after we pass C-14, as it's currently written. And this is why Kay Carter wasn't about to die from her illness. She had a spinal stenosis that would not kill her. And I want to refer to specifically the way Jocelyn Downey, professor of both law and medicine at Dalhousie University, described it. And in her view, that C-14 is unconstitutional. I just want to read this excerpt from Professor Downey. Quote, "There was no evidence on the record before the court that Kay Carter's death was reasonably foreseeable in any temporally proximate way. In fact, it was just the opposite. To pick but one of many possible examples from the evidence before the court, as Kay Carter wrote in her letter to the Dignitas Clinic in Forch, Switzerland, quote, the neurologist, Dr. Cameron of North Vancouver, assessed me and I had a CAT scan and MRI done. From these tests, he told me that I had an ongoing, slow deterioration of the nerves that would never kill me, but eventually would reduce me to lie flat in a bed and never move," close quote. In other words, Kay Carter would not fit the definition within the bill, the requirement that to be grievous and irremediably affected in a condition that would allow medically assisted death would be a death that was reasonably foreseeable. Now, that clearly suggests, although the language is somewhat vague, that this government's bill, C-14, requires that a person to be grievous and irremediable within the meanings of the Act to access medically assisted dying has to be in a terminal state. The court, in its unanimous decision, may have left, for those who were hoping to find a loophole, some ambiguity. But I don't think it's there when the fact of the case right in front of them, Kay Carter, was not in a terminal state. And beyond that, when the government went back to the court, and of course this is where I have sympathies for the current government, the Supreme Court gave a year from the date of their decision in February 2015, but the Minister of Justice wasn't sworn in until November 4th. The Prime Minister wasn't sworn in until November 4th. The time limits imposed on the new Liberal government are not of their making, and I am clearly sympathetic. But I opposed at the time going to ask the court for an extension, because deadlines such as this, given that the effect of the court's decision rendering those criminal code sections unconstitutional, I do not believe will create chaos or a situation that can't be managed. But to go back to that moment when the Government of Canada went to the Supreme Court to obtain an extension, and in this excerpt, Madam Justice Karakatsanis says clearly in questioning one of the counsel, and I'll quote her, the whole context is she's asking, I'm thinking particularly about somebody that has to be à la fin de vie, whereas in Carter, we rejected terminally ill. Let me just put it again clearly. Supreme Court of Canada Justice says, in Carter, we rejected terminally ill. That's clearly the standard for ensuring that rights are protected, is that you must not ensure that in order to access medically assisted death, the person be on the verge of death, that their death be reasonably foreseeable, even if we take reasonably foreseeable back to a year or 2 years. Kay Carter didn't have that circumstance. Another medical expert who's written about C-14 since it came forward, Professor Jesse Powerchuk, who's a clinical assistant professor of medicine at the University of British Columbia, wrote, quote, worse, the wording of the proposed law introduces significant doubt as to whether an Alzheimer's patient who is yet to lose capacity, yet is certain to, would even be eligible, since death can take years, even from the point of entering long-term nursing care. Foreseeable death and advanced state of declining capability are loaded, ambiguous clauses that seem to eliminate the charter rights of dementia patients and to put any physician carrying out their wishes in considerable legal peril. Without these amendments passing at report stage, I can't vote for C-14. In an ideal world, I would rather there was a framework of laws for doctors to follow, for nurse practitioners to follow, for a framework and consent and the forms and the witnesses and the independence and the elements of this law. But if these amendments aren't passed, I can't vote for a law that falls below the bar of what the Supreme Court says constitutes protection of charter rights. Thank you, Madam Speaker.